One of the difficult things about abortion access in Texas is that it's an issue that gets covered in the media a lot, that people have strong feelings about, but that is, from a legal standpoint, extremely complicated.
Let's be clear about what the law is in Texas. Only a physician may perform an abortion, and that physician may only perform an abortion if he or she determines in the exercise of reasonable medical judgment that the woman has a life-threatening physical condition that either puts her at risk of death or at substantial risk of impairment of a major bodily function.
Currently, Texas law has 3 different abortion bans in it. And the first one is law that was enacted and codified in 1912, 1918, and we think of that as like the pre-Roe criminal statutes for abortion. And that law had always been blocked by the court in the Roe versus Wade case. But the legislature had never officially repealed it. It had just become dormant and shifted off to a different section of the code. Second to that, we have Senate Bill 8, which creates a civil cause of action for any abortion that doesn't meet the requirements of Senate Bill 8. And those requirements are that a doctor has to perform a sonogram, check for a fetal cardiac activity before an abortion can be performed. And then the third ban is a felony criminal abortion ban that's a first-degree felony, which is a penalty of 20 to 99 years to life. It also contains civil penalties that the Attorney General can enforce with a fine of up to $100,000. The heartbeat bill is what we think of as Senate Bill 8, or the chapter in the code that creates a civil cause of action where people could sue someone who helped a person get an abortion that didn't comply with the requirements that a heartbeat not be detected in the pregnancy before the abortion was performed. The trigger ban is called that because it was not triggered and did not go into effect until the Supreme Court overturned Roe in the Dobbs case. So it is the felony criminal abortion ban with the severe civil penalties that the Attorney General can bring also.
And once the trigger law took effect, Texas has now several prohibitions in various statutes against abortion. They don't all have the exact same wording. There are no exceptions for rape and incest. And there is still uncertainty about whether the laws that were struck down by Roe are still in effect. I think that there are different perspectives on the historical background of those laws, but it's definitely the case that one reason for the Civil War-ish era laws was the concern that women were dying as the result of botched procedures. So there was definitely sort of a protective element to the laws and a concern that there needed to be more rigor in the law about who could perform an abortion. You saw also at this time the beginning of an attempt to create what we now have as sort of our professional practice laws. And so this was the time when the country was first starting to define what a dentist could do and what their scope of practice would be, what a physician could do and what their scope of practice would be, what a nurse could do and what the scope of practice would be. So you see those attempts to sort of professionalize and standardize these different disciplines and make sure that the people that were performing those services had the appropriate training and credentials.
The other thing that's important to know about the pre-Roe statute is that it does not contain an exception to prosecution for the pregnant mother. And this is why the anti-abortion movement is really keen on getting it enacted or enforceable, because that would allow them to punish, prosecute, or at the very least dissuade pregnant people in Texas from either self-managing their own abortion or getting telehealth abortion with a provider in a different state where the provider was protected. The civil liability, the Heartbeat Act or Senate Bill 8, does contain an exception for the pregnant mother. The pregnant person can't be sued, and the trigger ban, the felony abortion ban, also contains an exception to prosecution for the pregnant person. Lots of Texans are able to travel to other states and get safe legal abortion in other states. Lots of Texans access medication abortion via telehealth or via the internet without a visit with another physician, and they're able to get that abortion care also. Now, they're able to get that care because there is an exception to the criminal penalty and the civil penalty for abortion for the pregnant person.
The trigger ban says that essentially performing an abortion is a crime. And There are many sort of detailed facets to the trigger ban. So there's also language ensuring that a physician would lose their license if they were found to perform an illegal abortion. And so it starts from a very broad criminal prohibition, and then it backs away from that broad criminal prohibition in very narrow, circumscribed ways, such as the handful of things that are excluded from the definition of quote-unquote abortion, and the language allowing a physician to perform an abortion if, in the exercise of reasonable medical judgment, the physician believes that the patient has a life-threatening physical condition that's being caused by or aggravated by the pregnancy that puts that woman at risk of death or at substantial risk of impairment of a major bodily function. And almost every one of those sort of big word terms has then a further definition in the law. So there's a definition of what abortion means. There's a definition of what reasonable medical judgment means. There is a definition in the labor code for major bodily function. There's not absolute clarity, however, again, on how sick the woman has to be, how soon the risk of death has to be, how high the risk of death has to be. And most doctors will tell you that it's already a challenging standard because the very fact that a woman is pregnant already means she is at a greater risk of death, and she already has a greater risk of substantial impairment of a major bodily function, because that is the nature of the condition of pregnancy, that it is a hard enough process. There is just a baseline greater risk that things could go south and the woman could die, or she could end up with her kidneys compromised or her uterus compromised or some other complication.
I think in this moment, a lot of people are really concerned about access to abortion and reproductive health care and really don't know what they can do about it. So I think an important thing is to be vocal about that concern, to not shy away about those tough conversations.
Texas has been sort of a laboratory for regulating this area of law for a long time. And I think that has now created this patchwork situation that we find ourselves in. And it's time to sort of step back and think holistically about the care that we all agree should be provided and how we can sort of, like I said, tinker with the laws or create a little space among the laws to make sure that care is still going to be provided.